everyone, Ashik this side. Welcome to my channel Kickstart Privacy. Your privacy journey start with me. In today's video, I will be talking about an important topic called privacy impact assessment versus data protection impact assessment. Alright, PIA and DPIA are two terms that often cause confusion. Right, let's start by understanding what they really mean and their key differences. Whether you are an organization looking to enhance privacy practices or an individual keen on understanding PIA or DPIA, this video will equip with the necessary knowledge to differentiate between PIA and DPIA effectively. Alright, let's move on to the topics covered. The topics covered are: what is the difference between these two, when and why it is required, the scope, legal requirements, emphasis and timing, the examples of PIA initiatives, processing activities that require a DPIA, sample DPIA steps for assessing sensitive data processing activities, and the conclusion. Alright. Let's see the difference between the DPIA and PIA first. So what is the difference? Privacy impact assessment. It is a broader term that refers to a process that is used to assess the impact of an initiative, project, program or policy on privacy. What about data protection impact assessment? DPIA is a process that is mandated by the GDPR for organizations to identify and mitigate potential privacy risks associated with new or existing data processing activities. Alright. Next, when and why it is required. Data protection impact assessments. A DPIA is required when the data processing activity involving personal data is likely to result in a high risk to the rights and freedom of individuals. The phrase likely to result in a high risk to the rights and freedom of individuals comes from the European GDPR. It is an important criterion used to determine when certain data protection measures such as DPIA must be carried out. But what does it mean in practice? So when it comes to the rights and freedoms, it refers to the fundamental rights and freedom individuals enjoy, with a particular emphasis on privacy and data protection rights. This includes the right to privacy, freedom from identity theft or fraud, freedom from discrimination and more. Then what this high risk implies to? It implies to a significant or elevated possibility that data processing activities might harm or infringe upon those rights and freedom. Alright. There are processing activities that may be considered likely to result in a high risk. I will explain it in the next coming slides in detail with some examples. Now, data privacy impact assessment, and I am going to the privacy impact assessment. It is a tool that helps organizations identify and assess the privacy risk associated with a particular initiative, project, programs involving personal data, and to develop strategies to mitigate those risks. Alright, now let's move on to the scope, legal requirement, emphasis and timing. What is the scope here? DPIA specifically focuses on data processing activities, while PIA is a broader assessment that can cover a wide range of initiatives that may impact privacy. What about the legal requirements? Legal requirements. DPIA is a legal requirements under GDPR for certain data processing activities, while PIA is not a legal requirement but is considered a best practice in many jurisdictions. What is emphasis here? Emphasis. DPIA places greater emphasis on the identification and mitigation of privacy risks associated with the data processing activities, but PIA places equal emphasis on identifying privacy risks and developing strategies to mitigate those risks. So if you look at it, DPIA has greater emphasis than the PIA. Why is that? While both PIAs and DPIAs focus on identification and mitigation of risk, the DPIA under GDPR has a more stringent requirements for ensuring data protection due to the potential high risk involved. Failure to conduct a proper DPIA when required or adequately address identified risks can result in significant penalties under the GDPR. That is why there is a heavy emphasis on both the identification and the mitigation of privacy risks in the case of DPIA process. All right, and finally the timing. DPIA is typically conducted before the implementation of a new data processing activity or when significant changes are made to an existing activity. But PIA can be conducted at any time point during the development and implementation of an initiative. All right. Now let's see what are the initiatives that may impact privacy. I have given you some examples of PIA initiatives. Let's see one by one. There are many initiatives that may impact privacy and require a privacy impact assessment to be conducted, but these are few examples I have given here. What are those? New technology implementations. The new technology implementation, the introduction of these new technologies such as facial recognition or biometric systems may collect and process personal data in ways that could impact privacy, right? A PIA can help identify and mitigate these risks. These are the two examples. What is the next one? Data sharing initiatives. Initiatives that involve sharing of personal data with third parties such as vendors or other organizations can pose privacy risk. A PIA can help assess the risk and ensure that adequate safeguards are in place to protect the data. These are two examples to the vendors and to the third-party organizations. What is the next one? Employee monitoring programs. Employee monitoring programs that track employee behavior such as internet usage or email communication may impact privacy. A PIA can help ensure that the program is necessary and proportionate and that adequate safeguards are in place to protect the employee privacy. These are the two examples: employee behavior such as internet usage or email communication. What is the next one? Marketing initiatives. Marketing initiatives that involve collecting and processing personal data such as for email campaigns or for targeted advertising may impact privacy. A PIA can help ensure that these initiatives comply with the relevant data protection regulations and that adequate safeguards are in place to protect the data. These are the two examples, email campaigns or targeted advertising. What is the next one? Research studies. Research studies that involve the collection and processing of personal data may impact privacy. A PIA again can help assess the risk associated with the study and ensure that appropriate measures are in place to protect the privacy of research participants. All right. So, when we say that these initiatives might impact privacy, we are referring to the potential effects, changes, or consequences on individuals' rights and expectations to keep their personal and sensitive information secure and free from unauthorized access, use, disclosure, or collection. So overall, any initiative that involves the collection, processing, or sharing of personal data may impact privacy and require a PIA to be conducted. A PIA can help ensure that these initiatives are conducted in a privacy compliant manner and that adequate safeguards are in place to protect the privacy of individuals whose data is being processed. Alright, now let's move on to see what are the data processing activities that require DPIA. Under the GDPR, organizations are required to conduct a data protection impact assessment for any processing activity that is likely to result in a high risks to the rights and freedom of individuals. Right. This means that not all processing activities require a DPIA, only those meet certain criteria. The GDPR provides a non-exhaustive list of processing activities that are likely to result in a high risk and require a DPIA. These include systematic and extensive processing activities. So, involving in your processing activities, if you involve large amount of personal data or processing that involves a large number of individuals. So, why is the risk? For example, if a company database containing personal information on millions of customers is breached, the data could be used for identity theft, financial fraud, or other harmful purposes, right? Next, processing of sensitive personal data. This includes processing of personal data that reveals racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership in the case of EU, genetic data, biometric data, health data, or data concerning a person's sex life or sexual orientation. For example, processing of health data such as medical records or genetic information can lead to discrimination, loss of insurance coverage for an individual if the data is misused or leaked. And another example for processing biometric data such as fingerprints, facial recognition data, or voice prints can be used for identification purposes, but it can also be misused or breached. If biometric data is leaked or hacked, an individual's identity could be compromised and they could suffer financial or reputational harm. Alright, what is next? Processing that involves profiling. This includes processing of personal data to evaluate certain personal aspects of an individual, such as their performance at work, economic situation, health, personal preferences, interest, behavior, location, or movements. I have one more along with profiling, which is automated decision making. This includes processing of personal data to make decisions that have legal or significant effects on the individual, such as credit scoring, automated recruitment, or e-recruiting and e-commerce activities. These two processing activities, profiling and automated decision making, are increasingly being used in hiring and recruitment processes, right? Where algorithms analyze personal data to determine the suitability of job candidates. If the algorithm is biased or inaccurate, it can result in discrimination against certain group of individuals, right? Let's move on to the next processing activity. Processing that involves tracking individuals' behavior. This includes processing of personal data to monitor an individual's behavior, such as online tracking for behavior advertising purposes, location tracking, and monitoring of employees. I have few examples. Employee monitoring. Monitoring employee activities such as email and internet use through some software tools, on a large scale. Location tracking. If you are tracking individuals' locations data through GPS devices or mobile phones on a large scale. Online behavior tracking. Collecting and analyzing individuals' online behavior such as browsing history and search engine queries on a large scale. And CCTV surveillance. Using CCTV cameras to monitor individuals' activities in public places on a large scale could be considered systematic monitoring. So these are the examples of processing personal data that involves tracking individuals' behaviors. What is the next one? Processing activities involving vulnerable individuals. So, if the processing activity involves vulnerable individuals such as children, elderly people, or individuals with disabilities, it may pose a high risk to their rights and freedom, even if the processing activity itself does not involve sensitive data or profiling. Alright, what is the next one? Processing activities involving new or innovative technologies. If the processing activity involves new or innovative technologies such as blockchain, artificial intelligence, or the Internet of Things, it may pose a high risk to the rights and freedom of individuals due to the potential for unintended consequences. Right? For example, a company launches a new smart home device that connects to the Internet of Things, allowing users to control home appliances, security systems, and even measure health metrics using voice commands. What is the risk here? The device, continuously listens for voice commands and might inadvertently record private messages, private conversations, storing them on company servers. This stored data could be accessed by the hackers or misused by the company itself. Moreover, if the device collects health metrics, without proper consent, or transparency, it could violate the rights and freedom of individuals by collecting sensitive personal data, without them being fully aware. All right, what is the next one? Processing activities involving international data transfers. If the processing activities involve international data transfers, it may pose a high risk to the rights and freedom of individuals due to the potential for inadequate data protection in the destination country. For example, outsourcing. Right. Companies may outsource their data processing or customer service activities to third-party providers located in different countries, which can result in personal data being transferred across borders. Right. If the third-party provider is not subject to the same data protection standards as the company, it can result in loss of control, misuse, or exploitation of the data. All right. What is next in the list? Processing activities involving public authorities or bodies. If the processing activities involves public authorities or bodies, it may pose a high risk to the rights and freedom of individuals due to the potential for abuse of power or infringement of individual rights. All right. So, it is important to note that these examples are not exhaustive and that organizations should conduct a thorough risk assessment to determine if DPIA is necessary for any processing activity that may pose a high risk to the rights and freedom of individuals. All right. And in the next slide, I have given sample steps for assessing sensitive data processing activities in an organization. All right. So I have 7 steps to complete. The first step is to describe the processing activities, outline the purposes for which sensitive personal data is being processed, specify the type of sensitive data being collected, for example, data, or racial or ethnic origin or other sensitive related information, and identify the source of the data. It may be directly from the individuals or maybe from the third party providers or from a public sources. In the second step, assess the necessity and proportionality. We need to determine if processing the sensitive data is truly necessary for the intended purpose and ensure that no more sensitive data than required is being processed. Step 3, identify and assess the risk. To identify the risk, we need to know the threats and vulnerabilities, right? Unauthorized access to sensitive data. This is the threat. What is the vulnerability? Example, it is due to weak passwords or insufficient access controls. Data breaches is due to cyber attacks or insider threats. Accidental disclosure. Example, misdirected emails. Inaccurate data collection or storage leading to misinformation. What is the risk here? It's identity theft or fraud. And of course, discrimination based on the sensitivity of the data or sensitive attributes. And assess the impact. Assess the potential harm to the individuals. Given the sensitive nature of the data, this could be substantial, such as serious emotional distress, financial hardship, or health repercussions, and evaluate the potential reputational, financial, and legal impacts on the organization. These comes under step 3. Next, move on to the step 4. Implement mitigation measures. Technical measures. A robust encryption for data at rest and in transit, because we are processing sensitive personal data. So we need to have a strong access controls and can use multi-factor authentication as well. And regularly update and patch the softwares and systems, implement also the intrusion detection system and prevention systems. What are the organizational measures? Staff training on handling sensitive data, clear policies on data storage, on sharing and retention, incident response plans in case of data breaches, regular audits and reviews of data processing activities. Transparency and control. We need to inform the data subjects about the processing of their sensitive data and its purpose. Allow data subjects to access, correct or delete their data. Obtain explicit and informed consent before processing. And step 5, consultation. Engage with the data subjects or their representatives to understand any additional concerns or insights. You can also consult with the data protection officers or the legal teams to ensure regulatory compliance. And step 6, document the DPIA. We need to keep a clear record of the DPIA process, its findings, and the implemented controls, measures. This documentation will be crucial for regulatory compliance and for demonstrating that adequate measures have been taken care. All right. And the last step is to monitor and review. Schedule a regular reviews of the DPIA, especially when there are changes in processing activities, technologies, or when new risks emerge. All right. So with this, I'm done with my presentation. I'm going to conclude with the organizations, should regularly assess their processing activities and determine if a PIA or DPIA is necessary. If in doubt, it's always best to consult with a data protection expert to ensure that all relevant risks are properly identified and addressed. All right. And thank you for watching. Stay tuned for more informative content on data privacy, best practices, and regulatory compliance. Please subscribe for all these to happen. Bye-bye. Thank you.